Welcome, everyone. I'm so pleased you were able to join us for this webinar. As we proceed along, more people will be joining, but I wanted to get some housekeeping matters out of the way first. We're going to begin the presentation with our speakers who will speak to us for approximately 20 minutes each, after which we will have questions. Please use the Q&A feature at the bottom of your screen to ask the questions. Don't use the chat feature, otherwise we won't get your question in. Also, we realized as we were putting this together that there was too much information for just 1 hour. So we're going to have part 2 in January. So pre-mark your calendars for one of the Fridays in January, the 8th, 15th, or 22nd. We'll be sending out more information about which Friday part 2 will be on, but please mark your calendars for that day. Now, because you don't want to hear me and you do want to hear the information, I'm going to turn the presentation now over to Professor Louisa Heiny and Judge Richard McKelvie, who will go through this topic, tell us what we need to know, and then fill us in January on how we apply what we learned. Thanks.
All right, I guess I'm starting, is that right? Okay, good afternoon, everyone, and thanks for being here. This is an exciting opportunity to talk about a topic that is very interesting and one that I've had a lot of experience with over the past almost 40 years of my career as both a prosecutor and now as a district court judge. Let me begin by telling you a story that involved a case that I had when I was a very young prosecutor. This would have been probably 1983 or 1984, after I'd been at a law school for only a couple of years. I was assigned to prosecute a pretty violent home invasion robbery in which two individuals, two males, broke into an elderly man's house, a World War II veteran, tied him up, cut him with a knife, stole a number of items from his home, and then escaped. If this story sounds familiar to some of you, it's because this is the story that I always use at the end of the trial advocacy semester lecture. And in that context, it's always been self-deprecating, feel-good stories that has kind of a funny ending. But it ties in directly with what we're talking about, and as you'll learn, but the ending is not necessarily as funny as what I always alluded to in trial advocacy. In any event, two individuals break into this man's home. He identifies them as both males, one Hispanic with black hair, one a Caucasian with blonde hair, both in their late 20s to early 30s. They're in his home for several hours. They rob him, they tie him up, they cut him with a knife to take the knife away from one of them, and they leave him there. Fortunately, because of a neighbor who was concerned about him, hadn't seen him out at a time when he normally would. He came over to check on him and found him tied up. They called the police, and an investigation ensued. Through really good detective work, which I won't go into in any detail here, they identified a suspect that mentioned a Hispanic man. His name was Richard Cintron. And so, under circumstances that we'll be talking about during the course of this seminar, the detective put together what we call a six-pack, a photo array of 6 individuals, including Mr. Cintron, and invited the victim down to the police station to look at this 6-pack of photos and determine whether or not he could identify the individual who robbed him. And he identified Mr. Cintron as the Hispanic of the two robbers. So they felt like they had something really solid to go on. They then started looking a little bit more into Mr. Cintron's background and found out that that Mr. Cintron frequently ran with a guy named John Price. Now, when I say ran, I don't mean in the way that I run when I go out and train for marathons or stuff, but like, you know, they hung out together and they did criminal acts together. So they got Mr. Price's photograph. They put it in another 6-pack. They invited the victim back down, and sure enough, the victim picked Mr. Price as well. So we now had our 2 suspects, charged them by information. Defense attorneys asked for an in-person lineup. And for those of you who haven't participated in them, it's exactly what it says. They used to do it at the old Metro jail. I'm not sure where they do them now, in a room where they just bring in 6 people that are picked at random, usually out of the jail, that match the description of the suspect. They're all in identical clothing. They stand behind a glass partition so that Witness can see them, but they can't see the witness. They may or may not be asked to say anything. And in this case, we had two different lineups, one for Mr. Price, one for Mr. Cintron. The victim picked both of them out of the lineup. So at this point, we feel really solid in our identification. Next step in this process is a preliminary hearing. Those of you who are familiar with how we do preliminary hearings today, this really usually wouldn't happen, where the victim comes in and testifies personally, because the state normally proceeds with victim through a 1102 statement, which is basically just a sworn affidavit identifying the defendant if necessary and pointing out what criminal offense occurred. But back in those days, we did a preliminary hearing. It was kind of like a mini trial. You brought the witness in, they testified. And again, he identifies both of the defendants as the perpetrators of this crime. And he tells a harrowing story, and he's a very captivating, believable witness. So we get to trial. Trying the case, I go through the entire story with the victim, and I draw it out as long as I can. And then I get to those questions that every prosecutor has asked 100 times, so we know exactly how to ask it. You ask it the same way every time. Mr. Jones, the person that you identified as the Hispanic robber, would you recognize him if you saw him again? Yes, I would. Do you see him in the courtroom today? Yes, I do. Will you point him out and describe what he's wearing? And of course, Mr. Jones Mr. Cintron and says, that's the guy right there. So then I ask him, all right, now you described the individual as being the blonde Caucasian. Would you recognize him if you saw him again? Yes, I would. Do you see him in the courtroom today? No, I don't. Now, my heart stopped, and I started going through the machinations that I had learned about how I can encounter, how I can cross-examine basically my own witness, how I can impeach my own witness based on the prior statements that he made at the preliminary hearing, the identifications elsewhere. And while that's going on through my mind, the witness says, "You're standing in my way." And I look at the witness, I look at where Mr. Price is, and I see where I'm standing. I move 2 steps to the left. I say, "Do you see him now?" He points to Mr. Price and says, "That's the guy." And of course, everybody in the courtroom, except for the defendants, bursts out in laughter. And I think that everybody in the courtroom knew at that point that probably this case was over with, that this witness came across as being so credible and believable that the jury was going to accept. And they did. So now comes the part that my students haven't heard before, and this is the rest of the story. And that's the thing that brings us here today. A couple of days after the trial was over, Mr. Cintron's counsel contacted me and said, "Mr. Cintron wants to come in and talk to you and to the detective." Made arrangements to meet Mr. Cintron, and he basically said, "I committed this crime, but Mr. Price was not involved. I did it with somebody else. And I'll tell you who that person is, but I will not be willing to testify against him. The only reason I'm going to tell you is so that you'll believe what I'm telling you is true." Now, obviously, we looked at that with some skepticism. I mean, he didn't come forward earlier. He had plenty of opportunities to do so, obviously. He sat back and waited for trial, as he and Mr. Price both spent several months sitting in the Salt Lake County jail waiting for trial, and didn't avail himself of an opportunity to exonerate this man. But we did some investigation into it. And sure enough, the individual that he identified was very, very similar in appearance to Mr. Price, was also a very close associate of Mr. Cintron's, didn't have an alibi, didn't admit to the crime, ultimately was never prosecuted for it because of 2 problems we had. Number one, Mr. Cintron wasn't willing to testify, and we didn't want to give him the immunity necessary to require him to testify. At that time in the state, and this is kind of a nuance, we had only transactional immunity and not use immunity. So you couldn't give somebody immunity just for their testimony. You had to basically cut them out of the case. And we had a victim who had already 4 times, under 4 different circumstances, positively identified Mr. Price as the culprit. So how are we going to put that victim on the stand and have him now say, "Oh, it was really this other guy," right? But it did give us an opportunity to dismiss the case against Mr. Price, which we did, because we no longer had confidence in our conviction as it related to him. I stand by the decision. I think it was a good decision to make. And I don't think that everybody would necessarily make that decision under the circumstances, which personally I think is regrettable, because our charter as prosecutors was always to try to do justice. And once you get to a point where your own confidence in the conviction is undermined, then in my view, you really have to step up and do the right thing. But the reason that this case is so important to what we're talking about is for two reasons. Number one, because it had every aspect, or almost every aspect, of the identification process that we will talk about. And it was a process that, in my view, led to an incorrect identification of an individual who was almost certainly factually innocent, and yet I got it wrong. At the end, the jury got it wrong. And even though these safeguards are there, we have to recognize the fact, and Louise is going to talk about that, Professor Heiny is going to talk about this more, the science behind it, that the thing that makes eyewitness identification so difficult is because there's probably no piece of evidence introduced in a criminal trial, at least, the credibility of which, as far as the jury is concerned, is as much at odds with the actual reliability of it. We were chatting a little bit before we formally started, talking about, DNA evidence is now kind of the vanguard of reliable evidence. We've used it so often, the science has become so rote that people just trust it, but it's boring. Juries don't like to listen to a lab tech say, I took this blood sample from this guy and I compared it to a blood sample that was found at the scene, and I put it through this machine and I came out with this chart, and here's the chart, and this is what it tells you. And that's terrific as far as this goes, but there's nothing that has the visceral reaction to a jury as having an aggrieved victim who has suffered a horrible crime point to an individual in court and say, that's the person who did it. And it's very compelling. It's very effective. And I used to say when I was a prosecutor, give me an eyewitness over physical evidence anytime. Not because I trust it more, but because I know that that's what the jury's going to fall on. So as we look at the jurisprudence of this, I want you to think about a few things. And one is that there is a little bit of difference in the way the state handles this and the way that the federal system handles it. And that has changed over the years. As early as 1986, our Utah Supreme Court case, or Utah Supreme Court recognized the fallibility of eyewitness identification in the case of State versus Long. And in that case, the Supreme Court basically pointed out a protocol that would have to go through and a jury instruction that would have to be given as in every instruction that I thought it was just literal length, 2 pages long, but it actually did come with the state from State versus Long. And it basically outlines to the jury the fallibility or the potential fallibility of eyewitness identification and the things that they should consider. But it goes all the way back to the process of the initial identification and the risks that are associated with that identification. I told you about the robbery case with Mr. Cintron and Mr. Price. Now think about this. This victim was actually exposed to these men for a greater period of time than most victims are to robbers. Most violent offenses take place over a period of seconds or minutes, as opposed to the few hours or so that these guys were in his house. But he was still under a great amount of stress. He'd been presented weapons. He was looking at people he had never known before. There are all kinds of reasons to be skeptical about his identification. But by the time he got to trial, he had had an opportunity to identify these individuals 3 different times under 3 different circumstances. And in each circumstance, his identity of that individual was at least tacitly given the imprimatur of the investigators by virtue of the fact that the case went on. In other words, if you're the victim of a crime and the detective calls you up and says, I want you to come and look at a photo spread, you're going to assume that he's found somebody that he believes committed the crime. And your job is to figure out who that person is, even if he tells you specifically, the person may or may not be here and goes through all the protocols that are necessary. The victim is thinking, I think I'm here to pick out somebody, so I'm going to pick out somebody that looks the most like the guy that did this. And if I get the right guy, then the case will go on. If I get the wrong guy, then nothing will happen because they know it's the wrong guy. So He picks somebody out in the lineup, in the photo spread, and the case continues. He goes to a lineup, there's 6 people there. Only one of those 6 people is among the 6 people who are in the photo spread. So in a way, his identification has been tacitly confirmed again by virtue of the fact that the person he picked out of the photo spread is now in this lineup with 5 other people he's never seen before. Now, then he gets to a preliminary hearing a month or 2 later. Here's the same guy. Now there's not 5 others. It's just him. He's there by himself, and he's in a prison uniform or in a jail uniform and shackled. And it's obvious to everybody in the courtroom who the suspect is. So by the time trial comes along, this victim has identified the defendant on at least 3 prior occasions, each of which has given the detectives an opportunity to tacitly confirm that that's the right idea. Let me give you an example of something that went the other way that was really disturbing to me. I was aware of a case in the county attorney's office that was a homicide case, and 2 eyewitnesses gone to a lineup. And one of them identified the suspect, the person who was the defendant in the case, and the other one identified a different individual. When it came time for preliminary hearing, both of those witnesses were subpoenaed. They were in the prosecutor's office and the prosecutor looked at both of them and said to the one who identified someone other than the suspect, "I'm not going to call you to testify because you picked out the wrong guy." Now, what message does that send to both of these witnesses? Number one, it tells the other witness that she picked the right guy, again, confirming by the prosecutor that this was the right person, and telling the other witness, "You got it wrong." Now, prosecutor wasn't there when the crime occurred. His information only comes from what he knows about the investigation. And yet he's told this witness, "You picked the wrong guy. I'm not going to call you as a witness." Now, obviously that's something that would have to be disclosed, you would hope, under the Giglio rule, but very, very disturbing nevertheless. I had another experience that I'll share with you quite briefly, in which a young woman who had some mental challenges was the victim of a sexual assault. And she came into an in-person lineup. The defense attorney was there in the lineup. The detective was there. And part of what happens in the lineup is the defense attorney basically gets to pick where his client is in the lineup. 1 through 6 is going to be number 2, number 4. They had it all set up. The defendant was in position number 2. The detective went out to get the victim in a different room. While the detective was out of the room, the defense attorney said, "You know what? I've changed my mind. I want the defendant in position number 4." So the defendant and number 4 switched positions. The victim came in with the detective who had been in there when the lineup was set up, and she immediately identified number 2 as the perpetrator. Obviously, that case didn't go any further because we knew number 2 had not committed the crime. We didn't have any evidence now to support the notion number 4 did. And I never thought to ask the defense attorney if he suspected something, and that's the reason that he did that. And of course, I never confronted the detective about whether or not he had a conversation with the victim, because I don't think he would have been honest with me. But those are the perils that you have to think about when these things come up. Louisa, I know I've already used up most of the time I had allotted. I don't know if we want to talk about a little bit about just the difference between where we are jurisprudentially in the state and the federal system as a result of both Supreme Court jurisprudence and the Supreme Court's rulemaking, the rules of evidence. We have really evolved to a point where in a state case, there are 3 things that can happen that become important to both sides in an identification. The first is that if identification is a significant issue, under our new rule of evidence 617, which Professor Heiny is going to talk about, the defendant is entitled to a hearing at which you can raise all of these issues. The court has to take into consideration in deciding whether or not to allow the testimony to begin with. It's kind of analogous to a Ramash hearing or a Daubert hearing where we act as the gatekeeper for expert testimony relates to eyewitness testimony. If the court excludes the evidence, of course, it doesn't come in. If the court includes the evidence, there are still 2 things that play that everybody needs to be aware of. Number 1 is that the court may but does not have to allow the defense to call an expert witness to talk about the inherent fallibility of eyewitness identification under different circumstances. The other part of that is that the court must, I think the term is shall, without discretion, shall give a jury instruction on the fallibility of eyewitness identification at the request of the defense. Federal system is more nuanced than that. I had a case a number of years ago that involved a string of subway robberies, the so-called subway bandit, and a number of people had identified him with varying degrees of accuracy or probability, their self-expressed probability. Defense filed a motion to, it notified us of their intention to call an expert witness about eyewitness identification. And I asked for a Daubert hearing. We had a hearing, and I convinced the trial court, and this was not that many years ago, it was shortly before I left the federal U.S. Attorney's Office, convinced the court that there was enough corroborating evidence about these crimes that this would be confusing and a waste of time, and under Rule 403, he excluded the testimony. Thereafter, the defendant entered a plea of guilty under Rule 11C1C of the Federal Rules of Criminal Procedure that allow the government and a defendant to pick a specific sentence, and then if the court decides that he won't impose or she won't impose that sentence, then the defendant's free to withdraw his plea. He entered that plea, and a number of the victims attended the plea colloquy. They came to court and watched this guy plead guilty. Thereafter, Judge Stewart rejected the plea agreement because he decided that the sentence wasn't lengthy enough. Now, imagine the quandary that put us in. How could we now put this victim or one of these victims on the stand and trust that their identification was the product of their own recollection of the crime when they sat in a courtroom and watched this man plead guilty, admitting to the very crime that they're now asking him to testify about? And more to the point, if you're a defense attorney and you want to challenge that identification on cross-examination, how do you do so without asking that witness, is this a product of your recollection of the crime? Or is it a product of your recollection of the day that the guy came into court and pled guilty to this crime? Obviously, you can't do that. Recognizing the difficulty of that, I filed a motion with Judge Stewart to reconsider his opinion and laid out the reasons for that. And without a hearing, he granted my motion to reconsider, and so we weren't faced with that prospect. But that's just a little bit about my experience with these issues, how it's evolved, and why it is that these rules are so important. Because even the best intentioned prosecutor or investigator, as I believe is the case with me in the Price and Cintron case, will occasionally get it wrong. And if those safeguards aren't there, then Mr. Price easily could have spent years in prison for a crime that he almost certainly didn't commit. So Louisa, unless there's anything else you want me to talk about, I'm going to turn this over to you.
Thanks, Judge McKelvie. As the judge said, we're going to split this into two pieces. I did an hour-long presentation on the rule itself a week or so ago, so we recognized we couldn't go through everything at the same time. Judge McKelvie and Justice Brennan are in the exact same boat. Justice Brennan said there's almost nothing more convincing than a live human being who takes a stand, points a finger at the defendant, and says, that's the one. At the same time, between 2/3 and 3/4 of DNA exonerations have involved at least one mistaken eyewitness ID. But IDs can be correct, and they can be the best or sometimes the only evidence in a case. So our goal here is to build a better ID. And the Utah Supreme Court has moved off Ramirez, and in State versus Lujan said, the way that we should look at IDs, admissibility and appellate challenge, is under Rule 617. So today we're going to talk about some of the science underpinning that rule, because some of it is very intuitive, but some of it is counterintuitive. And then Rich and I will come back in January and talk specifically about how to litigate some of this. So in evidence class, you probably started talking about observation when we talked about the 4 capacities that make up competency. and the need to be able to accurately observe. The rule also starts with observation. Now, we know some of the things that we frequently impeach on observational capacity. Low lighting, did you have your glasses on? How old are you? How well can you see? The science actually would tell us you should be looking a little bit deeper in thinking about how your witness has observed, because different people actually observe things in different ways. So here's a great example. You might remember this if you're on Facebook, the Great Blue Dress Challenge. Is this a gold dress or is it a blue dress? Internet was all afire on making this decision. All of us, crowdsourcing, were looking at this photo, ostensibly under the same conditions, and coming to radically different decisions about the description of the color of the dress. And really it's because your brain, Rich's brain compared to my brain, looks at the same information, the light that's coming in, and rather than looking at the dress, makes decisions about whether the dress is being shown in daylight or artificial light. And that's what changed the way our brains processed it. Similarly, observations can change very subtly when you think about the direction of gaze. So when we think about maximum acuity for your witness, we're thinking about what's happening straight on. That's where you do the finest work, whether it's reading or even watching my face right now when you're trying to read social cues. If your witness is looking even a little bit off center, that's going to change the accuracy of what the witness sees. And when I say a little bit, I mean like 10 degrees off center. So you've got somebody looking on the stairs above or below. You have a child and an adult looking above or below. That's going to change. It's not just going to change facial features, but it can change the way the witness looks at gender, age, and even race. All right, next kind of counterintuitive concept that underpins our rule is weapon focus. We think, or the public might think, that the presence of a weapon focuses the witness and improves the recall of the witness. So the witness might say, I will never forget the face of the man who pointed that gun at me. And the reality of it is that part of that statement is true. Research suggests that the presence of a weapon focuses and captures the witness's attention. But at the same time, it may impede the ability of the witness to attend to other important information going on around her, including the face of the perpetrator. And the same is true of other very highly emotional stimuli, highly stressful situations. People under great stress generally encode information differently. You can think of this as when you're afraid. Human beings are not hardwired to stare at the things that we are afraid of. So actually stress, whether it's weapon focus or from some other stimuli, does some maybe helpful things with your witness ID and some harmful things with your witness ID. So one thing that stress does is it creates a very enduring ID. Long-term retention is increased. And these memories are very vivid for witnesses. When they tell the story, it will be like they are reliving the highly stressful situation. Now, they also are frequently retold multiple times by witnesses. And unfortunately, what can happen in that retelling is witnesses will begin to fold into their memory information that they're receiving from other sources, whether it's a detective or an attorney or another witness or even a journalist, that can change in subtle ways their memory. Now, the problem is because these are so enduring, but can be inaccurate, they are held with very high confidence by witnesses. So witnesses end up being very, very certain and perhaps very or somewhat inaccurate. So it's this breakdown between accuracy and confidence that undermines, that witness ID. And cross-examination of these witnesses can be very difficult, because cross-examination works really well if you have a witness who's being deceptive. But these witnesses do not think that they are being deceptive. They are telling the truth as their brains remember that truth. It's just that they may be inaccurate. All right, what about not much stress at all? This is sometimes called unattended content, and it can be as bad as highly stimulating content. So too much stress is a problem. Too little stress can be harmful as well. We often think, well, I would know that, you know, if the bank were being robbed, I would have known that happened. But we frequently don't notice things, even extraordinary things that are going on around us, if the content is unattended. It never gets encoded in your brain. So my favorite example of this, you may have seen this on the internet or in a psych class at some point in your undergraduate days, the invisible gorilla. This is the experiment where they show witnesses a video, kids playing basketball, and they ask the witness, please count the number of times the ball bounces or is passed between the team wearing white or the team wearing black. In the middle of this video, a guy in a gorilla suit walks through the middle of the scene, stops in the middle of the basketball game, turns around and walks out. And they ask these witnesses after the fact, did you see anything? Anything strange happen, like a gorilla? And 50% of witnesses never saw the gorilla. My youngest daughter actually did this at school, and she said, I didn't see the gorilla. So be concerned, or at least cognizant of unattended content. Sometimes you will have a witness who is extremely detail focused. This can be very convincing to a jury or to an investigator. You have, for example, I'm working on a book on a case where this child remembered all kinds of details. What the suspect's shoes looked like, how the car was started, what the blanket looked like, what the sidewalk looked like, the color of the towels in the bathroom. When you have a witness who's extraordinarily detailed focused, you need to think about their total bandwidth. When they are focusing on some of these details, it might be to the exclusion of details about the perpetrator himself or herself. So they're not perhaps encoding memory about the face. Instead, they're encoding memory about everything around the face. This one you may have heard of, own race bias, sometimes called same race bias. The idea is that we are better at identifying people with accuracy if they are the same race that we are. So faces of people of races that are different from ours are harder to identify accurately. So I, as a white woman, will be more accurate if the suspect or the person I saw is also white. This happens across the spectrum. I would find it more difficult to accurately identify someone who is Black or Asian, but the reverse would also be true. Sometimes attorneys try to moderate or ameliorate this effect by asking witnesses, how often do you come into contact with people from whatever the race of the suspect is? Or are you biased or are you prejudiced against people from the race where the suspect or of the suspect? And really that's asking the wrong question. If you want to test same race bias in a witness, the question should be not how often do you come across people of that race. So white storekeeper with lots of Black customers or vice versa, that's not what's important. What's important is what kind of relationships does your witness have with people of a different race. It's not who they see on a daily basis, it's who you know. All right, the next somewhat counterintuitive, maybe a little more intuitive concept explains why I remember nothing of secured transactions. It's the forgetting curve. And of course, we know that memories can degrade over time. This is a very famous study that's been replicated more or less multiple times about how quickly memories can degrade. They actually degrade faster than we might expect. And a couple things happen in this curve. The first is, during that curve, memories can be in some way enhanced or distorted by the information that the witness is getting. Again, from anyone, another witness, a family member, an attorney, a detective, a journalist. Also, the ability to accurately remember drops off faster if you have a witness who is less confident from the beginning about the identification, or where the witness has something going on like same race bias. Rich talked a little bit about the commitment effect. This is, of course, the idea that he talked about multiple identifications actually encoding information in the brain about what you've seen each time. After time, you try to identify what you identified before rather than the suspect. All right, what about composites? Composites are generally not recommended anymore. Most studies show that composites are actually pretty bad. Controlled studies show that the actual face of an alleged perpetrator is generally significantly different from the face that appears in the composite. Part of the problem is that we tend to see individual features. Something that's very distinguishing about the person will stand out, and the rest of the features will fade back. But when we create a composite, we are now locking that composite into our witness's memory. So then the witness may, in a photo array or a lineup, a six-pack, try to identify the person who looks most like the composite rather than looking for the perpetrator as they remember it pre-composite. A good way to kind of think about the reliability of composites is to think for a moment, could you please describe your father's nose or your mother's nose or your children's eyes? I tried this, I actually couldn't describe it in a way that would have been useful. And imagine if you were asked to do that for someone you do not know, who you only saw very briefly. You can imagine you might not be particularly accurate. Rich already talked about, Judge McKelvie talked about taint during a lineup or a photo array, and that can be conscious or unconscious. So he talked about, we found the guy, we need you to ID the guy. But sometimes there's even very subtle post-identification, good job, well done, or even nodding at another detective in the room, or smiling, something that is almost unconscious. Witnesses can conform to these very small details. It makes them more likely to pick someone, as Judge McKelvie said, they think that that is their job. So what can help? You want to be looking for double-blind procedures, and if there aren't double-blind, blinded. So what's the difference? Double-blind procedures is where no one in the room, except the defense attorney, knows who the suspect is in the lineup or in the photo array. The idea is if you don't know who the guy is or who we think the guy might be, then you cannot give either these conscious or even unconscious signals to our witness. If you can't do double blind, you may not be able to. You may have an officer or detective in a smaller agency or in a big name case like the subway robber that Judge McKelvie referenced, where everybody knows who the suspect is. And then when that happens, you want to be looking for blinded arrays, which means that even if the administrator knows who the suspect is, we have a folder shuffle going on or something similar, and the administrator can't see the photos at the same time the witness sees the photos. So perhaps with a computer screen in between them. Without blinded or double blind or blinded arrays, we need to be concerned about either purposeful or accidental taint. Regardless of what kind of show up or lineup you have, you've got to record it. And when you record it, one of the things you should be looking for is a witness who gives a confident statement. A confident statement is just a statement in the witness's own words about how confident he or she is in the identification that he or she just made. It doesn't have to be complicated. All we want to ask is, how sure are you? And if the witness says something like, well, I think it's number 4, we just want to follow up with, you said you think it was number 4. What does that mean? We record this, and the reason we do it is because the confident statement reported by the witness at the time of the very first ID is actually a greater indication of accuracy than what they say at trial. If you don't have this recording at the time of the initial ID, then what happens is you end up with hindsight bias, where as we go on, and Judge McKelvie alluded to this, the person starts to think, well, I was sure about this identification all the time. All right, just 1 or 2 more things. Pay attention to recognition versus recall. Recognition is a super rapid process. Recall is a very deliberate process. So if you have a witness making an identification, the identification accuracy is diminishing the longer that they are considering. So if the real perpetrator is in the lineup or the show-ups are a whole different kettle of fish that are addressed separately in the rule, or the photo array, the witness usually makes an ID within a couple of seconds. If it's more than 30 seconds, then we need to be very concerned about whether this is recognition, very rapid, or recall, more of a look back into the memory. So that's just a slice, and a very quick slice, of some of the science that went into the development of Rule 617. The advisory committee and the Supreme Court looked at all of this science. We actually have, I think, some of the researchers at the University of Utah who worked on some of these studies and helped the advisory committee here on our call. So hopefully they'll be nice in the chat box or the Q&A if I got anything wrong. But Judge McKelvie and I are looking forward to your questions and a conversation. And I know I'm available if we run a little over. I think the judge is as well.
Thank you both. I really appreciate that. One question that springs to mind is, how long was the working group working on all of this to develop the rule?
I don't know the answer to that. I know it was a long process. Judge McKelvie, do you know? I'm not on the advisory committee.
I am on the advisory committee, and I was when the rule was ultimately promulgated, but I wasn't on it for the entire time. But I do know it was a lengthy process. I'd say at least a couple of years. I mean, those things never happen quickly because they're subject to such thorough review. The committee only meets 5 or 6 times a year. And then committee members are given specific assignments to go back and do research or talk to people, to try to come up with the best ideas. A lot of times the legislature gets involved. We'll have a legislator that has some specific concerns about some rule of evidence that he wants us to look at. So it really is, I won't say that it's a cumbersome process, it's just not a simple one. And then of course, ultimately the Supreme Court has to adopt the rule. And they'll often send stuff back to us and say, you didn't get this quite right. Do a little bit more work on it.
And I actually see in the Q&A, Professor Yaffe is, I don't know if I'm pronouncing her name correctly, is here with us. And she was one of, I think, Judge, wasn't she one of the scientists that helped with the rule and the studies behind the rule?
I believe so, yes.
So what happens, practically speaking, if you do everything right, but you get it wrong? Well, find out after the fact that you get it wrong.
I mean, I think that the story that I told at the beginning, it suggests at least what my belief is, and that is, it's never too late to undo an injustice, as long as the people who are involved in that injustice recognize it and are willing to put their careers, their reputations, whatever it is, on the line in order to go into court, sometimes against the wishes of the police agency that's involved, certainly sometimes in opposition to what the victim wants to have happen, and say, I no longer have confidence in this conviction. Sometimes that doesn't work. Courts don't have to dismiss cases just because prosecutors want them to. You can ask General Flynn about that, but at least we don't know how that's going to work out in the final analysis. But typically, I can't think of a judge listening to a prosecutor that says, look, we believe that we've convicted an innocent person, and let me tell you why, and we're filing a motion to dismiss the case post-conviction. I can't think of a judge that's not going to give that some very serious consideration and would probably deny that motion only if they believed that either the prosecutor was going on a lark or they were really misinformed or having the wool pulled over their eyes.
But does that eliminate your ability to get the actual perpetrator?
Well, in this case, that was made unavailable to us. As I explained, number one, because Mr. Cintron wasn't willing to testify and we wouldn't have the ability to give him immunity under the way the state system was at that time. And because it didn't make a lot of sense to try to get this victim off of the price rails, so to speak, and say, hey, we know, we asked you this all these different times and boy, we were right behind you, but we think you got it wrong. We want you to look at some other pictures and see if you can pick the guy who really did this. There's no way, I don't think, you could convince a jury to convict this guy unless he either confessed or you found a fingerprint or some other really compelling evidence other than the eyewitness identification.
So, Laura,
and sometimes people go free.
Two thoughts on
that's
that.
The price we pay.
One is this case that I alluded to that I'm writing about. In that case, exactly what the judge is talking about, the prosecutors filed a motion and the judge, he was exonerated. It's in Arizona, so I don't know exactly what they call their procedure. Because there was DNA evidence, they then charged and were able to convict the second defendant. He pled guilty eventually. But it also reminds me, there's as you know, some of the federal appellate courts audio tape their hearings. And the Third Circuit had a hearing in January where a state prosecutor came in. It was a habeas case on a murder. The defendant had argued that there was such a substantial problem in the jury instructions that he should get a new trial. And in the Third Circuit, the prosecutor came in and said, the more I work on this case, the more I realize the defendant is right. And please, in this case, it was affirming the federal district court. And one of the Third Circuit judges said, we don't reject wisdom because it comes too late. And you as a prosecutor are doing exactly what we ask prosecutors to do, which is to do substantial justice.
Okay.
Sure.
The question, in about what percentage of trial cases are eyewitnesses the most significant evidence?
Boy, that's really subjective, obviously. I would say that probably in no more than 20 or 30% of the cases is the eyewitness testimony the most critical issue and the issue that the prosecution is relying on primarily in order to secure a conviction. Usually, even if there's eyewitness identification in play, and there oftentimes is, there is substantial corroborating information, which example is where the Supreme Court came down on the Lujan case, said that even if we didn't allow this identification and there was sufficient supporting testimony, that we have confidence that the jury got it right, and so we're not going to reverse the conviction.
So when you have, say, DNA testimony, fingerprint, something like that, as well as eyewitness, do you use the eyewitness simply to bolster the physical evidence, or do you use it as the primary piece?
Well, I'm going to have to go back and put on my prosecutor hat to think back on, 6 years ago when I used to do this kind of stuff. If I have that DNA evidence or fingerprint evidence or something like that, that increases exponentially my confidence in the witness's testimony. But I still recognize the fact that from the standpoint of getting a visceral reaction from the jury, that I'm going to lead with that witness and then bring everything else in to corroborate it. I'm not going to bring in the DNA evidence and the fingerprint evidence and then say, oh, by the way, the victim is here. And, you know, as long as she's here, we may as well ask her if she can identify the guy, but if she can't, it's not a big deal.
So how much has the new rule changed the way practitioners now go about dealing with eyewitness testimony?
That's a really hard question to answer, because
Okay.
the rule was promulgated and finally passed in 2019, in November of 2019, a little bit less than a year ago. And in February of 2020, our court system is basically shut down.
Right.
In terms of jury trials, at least. We haven't had a criminal jury trial in the 3rd District, as far as I know, since early March. And we don't know when that's going to change. So
Okay.
since this is such a trial-based area, we really haven't had much of an opportunity to litigate it under the new rule.
Okay. What are the best practices for in-person show-up procedures versus photo arrays? It seems that a crime scene show-up ID could be substantially more suggestive than a double-blind photo ID.
Yeah, the rule treats show-up separately and does recognize that possibility of substantial prejudice. So again, just like with the estimator variables that we talked about, things like ability to observe, the rule asks the judges to look at a variety of factors, including did you get a confidence statement that you recorded regarding, sorry, I'm doing that backwards. Did you get a recorded description at the front end? When you did the show up, did you do anything that tried purposely to match the suspect to the description? Did you, for example, have him put on specific clothes? Also, they prefer, or the rule prefers, that you not be doing a show up like on the side of the road, that the suspect not be in custody, or at least not in custody where the witness knows that. So not in the back of the police car, not standing in handcuffs on the sidewalk. Instead, also, you know, thinking about, did they take them to the station? Let's see, Rich, what am I leaving out on that show up procedure?
I don't think you're leaving anything out. I think you're pretty accurate. I think it's just interesting, the juxtaposition between show-ups and lineups, and the fact that, you know, show-ups are obviously fraught with all kinds of problems because it's one person, and so you know, you're not picking among anybody. But on the other hand, a show-up usually occurs because the suspect is captured very shortly after the crime in close proximity, oftentimes wearing the same clothing that they were wearing at the time of the crime. And so those circumstances, as you can see in the Lujan case, which talks about that, give the identification some corroborating support that isn't shown if you just show somebody 6 photographs in a detective's office 3 weeks after the crime occurred.
And the rule recognizes that so certainly they can be highly prejudicial. Under some circumstances, they're also necessary for the development of probable cause in the case. So judges are asked to look at whether they were necessary for probable cause development.
Okay. Setting aside the rule of evidence and the long-standing use of eyewitnesses in the common law and looking solely at the literature, is there any scientific consensus supporting the notion that third-party eyewitness IDs are reliable? Eyewitnesses that know the defendant personally are a different story, but is there any scientific consensus supporting the notion that third-party eyewitness IDs are reliable?
So I'm going to hedge just a little bit and say, when I did this research, I started to get really depressed because I was thinking, is there any ID in the world that we can actually trust? And I think the answer is yes, when it's structured and protected in the right ways. Do you have other thoughts on that, Rich?
No, it's obviously a fact of our existence. And even though in most cases that we see that actually go to trial, there's strong corroborating evidence, it remains the fact that sometimes eyewitness testimony identifying a stranger who committed an offense is the only testimony upon which a prosecution can be based. And at that point, I suppose we all have to have faith in the system, but we also have to recognize the fact, as you know, those of you who've been involved in the Innocence Project a lot, recognize is that we don't always get it right. And the only thing that we can hope for is that for the, to the extent possible, when we get it wrong in a way that that exonerates rather than implicates an individual. The old saw about, it's better for 10 guilty men to go free than one innocent person to be convicted. It has some merit in our system of justice, and it's unfortunate that sometimes means that people are get away with their crimes, so to speak. That's not what our primary objective ought to be.
One thing I think it's important to think about when we think about the scientific literature is the way that we structure a study. So I think normally what we're trying to do, keeping in mind I was an English major, is to create a hypothesis involving a single factor. So we can say single factors over time in certain populations increase or decrease the accuracy in controlled studies. I think it's very difficult, though, when you start to layer factor upon factor upon factor to say that there's a consensus, a broad consensus that they are or are not reliable.
Okay. Thank you, both of you, very much. This was fascinating information. Remember, everyone who's listening, we will send the slideshow out after this is over, along with the CLE certificates. And part 2 of this, which we're going to delve more into the nuts and bolts of the rule, as well as litigating the rule, in part 2 of this in January. So set aside time on your calendars now. Look for information coming up on that soon. And thank you all for attending and participating.